Oh, yay, oh, yay, oh, yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hivner. Good morning, everyone. Welcome. This is the Tennessee Court of Criminal Appeals. My name is Robert Wiedemeyer. I'm the presiding judge on this panel. My colleagues are Robert H. Montgomery Jr. from Kingsport, Tennessee, and Judge Timothy L. Easter from Williamson County, Tennessee. We're pleased to be able to handle this case via Zoom and live stream on YouTube, et cetera, et cetera. So we want to thank Nick Morgan and the folks over at the AOC and also the people at Mr. Hivner's office for handling the technology to make this possible for us to hear the case in this fashion. That being said, we will proceed as if we were in the courtroom, and each side has 20 minutes to argue. I think both of these attorneys have been in our court numerous times, so you know how it works. Ms. Harwell, if you want some rebuttal time, let me know at the beginning, and I'll try to help you keep up with your time. Mr. Hivner, are there any preliminary matters? I think I've covered what I need to.
No other matters, Your Honor.
All right, thank you. You can call the case, please.
Oscar Smith versus State of Tennessee.
All right, Ms. Harwell, you ready?
Good morning, Your Honors. I want to ensure that you can hear me.
I can hear you.
Okay.
Yes.
Thank you. I have a fancy microphone that requires me to push on and off, and so I wanted to make sure I did that properly. Yes, may it please the court, I'm Amy Harwell of the Office of the Federal Public Defender for the Middle District of Tennessee, and I, along with Catherine Dix, represent the appellant in this matter. Judge Wiedemeyer, I would like to reserve 5 minutes for rebuttal, if I may.
All right, certainly.
This is a case about whether evidence that decimates the scientific reliability of the identification of the perpetrator at trial is favorable under the new Fingerprint Act that was just passed earlier last year. While I really want to address any concerns that the court has, in thinking about this morning, I had planned sort of 3 primary areas to cover. I would like to begin with the operation of the Fingerprint Act itself and explain to the court why we believe that the act functions to entitle us to a hearing straight away without proceeding through all of the portions of the act. Then I would like to touch briefly on why the state's statutory construction argument set out in their brief is irrelevant to the fact that we are entitled to a remand from this court. And then I would like to spend most of my time focused on the errors of the trial court in that she applied the wrong standards, both as to our entitlement to testing under 405 and to a hearing under 412. Unless the court would rather I proceed in some other fashion, that would be my plan.
That's fine. I neglected to say a moment ago that we have read the briefs, both parties' briefs, and Ms. Harwell's reply brief. So I just wanted you to know that when you proceed. So thank you.
Thank you. And I realize that I appreciate the court having an expedited schedule for this oral argument. So I realize they may be more fresh in your mind since we just filed the reply brief just last week, that there's not been much lapse of time in the court's review. So I would like to start with the operation of the Fingerprint Act and why we believe that it was appropriate to ask the court straight away for a hearing under 412. And I don't want to get too bogged down in this portion of my argument, but I do want to point out several salient points in the act itself that indicates that 412 is not limited only, as the state claimed, to cases where the petitioner has asked for testing from the post-conviction court itself. I'd like to start with 403, which expressly limits applications for testing in the post-conviction court to testing of prints that are, quote, in the possession or control of the prosecution, law enforcement, laboratory, or court. That was not the case here. The print that we tested and that we believe to be relevant in this case was provided to us in federal discovery by the Attorney General's office. It came on a disc with a sticker on it that said it was generated by the Metro Police Department. And I know the court has, as you said, read the briefs, so is aware of the testimony about how that print, which print it was. But it was not a print that was only in the custody or control of prosecution or law enforcement. So we believe that under 403, we weren't required to ask for testing from the post-conviction court. 406, the provision right after the testing provisions, 404 and 405, makes clear that if 404 and 405 apply, 406 then is about who pays. It uses a limiting clause. If an order is issued pursuant to 404 or 405, then this is who pays. 408 comes most closely to discussing our situation and sets out what the court and the parties are to do if there has been testing by an independent or outside examiner, and requires disclosure of those examiners' results if there has been an outside examination. And we followed 408 in this circumstance. And then 412 discusses which lab is to do the analysis, again with a clarifying phrase. If the court orders analysis, then 412 applies as to which lab should do the analysis. All of this matters because none of these sort of qualifying provisions appear in 412. The provision in the statute mandating a hearing does not have if the post-conviction court orders testing or if testing is given under 404 or 405. Rather, it just simply says that testing, that a hearing shall be granted if the results of the testing are favorable to the petitioner. And I would submit that under the canons of statutory construction, given that the legislature clearly knew how to limit several of those provisions to circumstances where if the post-conviction court has ordered testing, the fact that 412 is not so limited means that the state's interpretation of the statute fails. And then I want to, as I said, touch very briefly on why the state's interpretation doesn't matter at all. And that is because whether under the state's interpretation of a petitioner should have to ask for testing from the post-conviction court before they get a hearing, or under our interpretation of the canons of statutory construction, as I've just outlined, either way, we asked for testing under this statute. It was an alternative form of relief requested from the post-conviction court, asking for testing on the basis of the evidence we already had. Turning to the things that the post-conviction court did wrong, the post-conviction court made two errors in denying testing of our sample. First of all, the post-conviction court did not assume that the results of the testing would be favorable, as was required by Powers versus State. And that is, I'm sure the court knows, the Tennessee Supreme Court case from 2011, where the Tennessee Supreme Court said, for purposes of determining whether tested is warranted. Now, granted, at that time, the court was talking about the DNA Act, but we know that the legislature intended the Fingerprint Act to closely track the DNA Act, so Powers is certainly instructive. For the purposes of determining whether testing is warranted, we must presume the testing results would prove favorable or exculpatory to the petitioner. And the reason I say favorable or exculpatory is because it depends on whether you're asking for testing under 404 or under 405. This court, that is the Court of Criminal Appeals, has followed that language in Powers multiple times, as applies to 405 cases or 305 cases under the DNA Act. They followed it in Johnson, Hart, and Rucker. That is to say, when a court is going to decide whether to allow testing or not, the question isn't whether the analysis will be favorable. The question is, if the analysis is favorable, would that have made a difference? And I submit that the court below erred on that second prong as well. And I think she erred on that second prong in part because she did not assume the results would be favorable. I think an analogy would be, by way of just being very clear, why the result would be favorable to Mr. Smith, or would change the outcome, if the testing were to show that the print matched a serial killer who's incarcerated in Texas. That would certainly change the calculus and undermine the confidence in the jury's verdict. And if the trial court or the post-conviction court below had presumed that the result would be that kind of favorable result, it would have been obvious to that court that the result would be different. However, even under our proof, even if the post-conviction court weren't to follow the Supreme Court's instruction in Powers, our proof, and just consider whether the result would be different with our proof, still under Powers, as discussed in our brief at page 29, we were entitled to testing. As Powers says, there's nothing in the act limiting DNA testing to only those cases where there's a tenuous evidence of guilt. Instead, what the post-conviction court did here was review all the proof that had been discussed in terms of a sufficiency of the evidence standard, and said, well, if there was new proof that was said that the fingerprint evidence was inconclusive, that wouldn't have rebutted all of these things that support the verdict. Powers says that's not the standard. Judge Easter, you joined an opinion in State versus Thomas back in 2016, where the panel you were on remanded for testing in a situation very similar to this situation we are in, where a favorable result would have impeached the key proof identifying the defendant as perpetrator. And we believe that this situation is very similar to that result in State versus Thomas. Also, Judge Wiedemeyer, I found really instructive language you wrote in Haddix versus State, which the Tennessee Supreme Court has cited multiple times with approval, particularly in Powers, that exculpatory results doesn't require that the results contemplated or the results of the testing must indicate with certainty that the petitioner is innocent, but rather could be something that impeaches the main evidence against the defendant. The other big mistake the trial court made below was in failing to properly consider residual doubt. And she did that, I think, in part, the only discussion she has in her opinion of residual doubt is in her denial of testing. But I think that while she doesn't even address it in her discussion of denying us a hearing, she did in the denial of testing say that she was denying it in part because under the pre-89 law, the statutory aggravators did not have to outweigh the mitigators beyond a reasonable doubt. The problem with that analysis that she clearly used in denying us both testing and a hearing is that she has the law wrong. Under the Sentencing Reform Act of 1989, anyone sentenced after November 1st of 89 gets benefit of the new act. That is found at TCA 4030-117. I know this court knows this part well. And there's also then the saving statute from 3911-112. Unfortunately, the post-conviction court considered the wrong law, but I'm here to tell you that Judge Wyatt, back as the trial judge, got the law right. If the court consults the record of the original trial at page 3275, Judge Wyatt instructed the jury that the aggravating circumstances had to outweigh the mitigators beyond a reasonable doubt. And that is the calculus this court must use to determine whether our proof that decimates the scientific reliability of the state's identification of our client as the perpetrator, is favorable or not. There's the other mistake the trial court made in that analysis is she failed to consider any of our proffered proof. I think in our brief, we covered fairly well her conflation of the term favorable with the term exculpatory, so I won't go back through that again. I hope that I made clear how she failed to consider any of our proof. Judge Montgomery in Waterford which is cited in the state's brief, you talk about the analysis that courts must engage in order to decide whether the particular evidence of innocence, how it interacts with the evidence of guilt. And that's the analysis that the post-conviction court below did not engage in. Finally, specifically as to sentencing, but across the board, the trial court, post-conviction court, I'm sorry, I'm used to talking about trial courts, and here it is the one in the same court. She failed to consider how the fact that this is scientific proof weighs in this calculus. I would take the court back to State versus Ballard, Tennessee Supreme Court case from '93, long before all potential jurors were armchair forensic analysts from watching NCIS over and over. The court back in '93 said, in the context of a criminal trial, expert scientific testimony solicits the danger of undue prejudice or confusing the issues and misleading the jury because of its aura of special reliability and trustworthiness. And that's what happened here. We have a fingerprint examiner testifying at trial without a doubt. This is the match. We have the state telling the jury, you can convict on the basis of Sergeant Hunter's testimony alone. And now we know that Sergeant Hunter's testimony wasn't reliable. He did not use the scientific methods available at the time, much less the ones available now. And his conclusion was scientifically unsupportable. I'm being passed a note that I've exceeded my time. If the court doesn't have questions for me now, I will reserve the remainder for rebuttal.
All right, thank you. General Simpson, you ready?
Yes, Your Honor. Good morning. May it please the court. Samantha Simpson on behalf of the state. Your Honors, this court should affirm the post-conviction court's determinations that the petitioner failed to establish his entitlement to fingerprint analysis or hearing. He presented the court with his own hand-picked analyst, but even that hand-picked expert's ambiguous analysis failed to establish a reasonable probability that he would have received a more favorable verdict or sentence. And because that inconclusive analysis was not favorable, the post-conviction court properly determined that a hearing was not warranted. Now, the petitioner's counsel discussed the statutory framework of the Post-Conviction Fingerprint Analysis Act, but the act specifically contemplates a hearing to consider the court-ordered analysis. Even the provision allowing a petitioner to file that petition specifically states that a petitioner may request fingerprint analysis. Now, while the act does contemplate situations like the one we have here, where there is pre-existing analysis, and that any party with that analysis is supposed to disclose that, when we look at the provisions that provide for the testing in conjunction with 410, which explicitly states that the analysis must be done by a court-ordered laboratory, and the court should first order the original laboratory if that's available, and if that laboratory is not available, then the court can order testing from a laboratory that it deems appropriate. After that court-ordered analysis is obtained, then the court looks at the results of the analysis, determines whether it's favorable, and whether the petitioner proceeds to the next step in this act, a hearing. So the petitioner's argument about the framework and construction of these statutes is simply not reflected in the plain language of if this court considers all of these statutes together. And here, the post-conviction court properly determined that the petitioner was not entitled to new court-ordered testing under the discretionary path. The petitioner does not contend that he's entitled to testing under the mandatory provision. So the post-conviction court analyzed the discretionary provision. And the post-conviction court determined that the jury would not have convicted the petitioner that had the palm print evidence not been presented to the jury. I'm sorry, there was no reasonable probability that the jury would not have convicted the petitioner had the palm print evidence not been presented, or if the jury had been informed that the source of the palm print cannot be determined. And the post-conviction court's determination is fully supported by the record. In making this determination, the trial court focused on the strength of the state's evidence, even excluding this Sergeant Hunter's testimony about the palm print. The jury, in its common knowledge and experience as lay people, could have looked at the petitioner who was missing the 2 middle fingers of his hand, looked at the palm print, which was also missing 2 middle fingers, and come to its own determination that the petitioner created that palm print. Additionally, the state presented significant evidence of the petitioner's guilt. One of the child victims was able to call 911 during the murders. And on this call, he states, "Oh God, Frank, no." The petitioner's name is Oscar Frank Smith. The jury could have relied on that evidence. Additionally, a neighbor observed the petitioner's white vehicle in the driveway of Judy's house during the time of the murders. And all was found in the room with Chad and Jason, and the petitioner was known to be a leather worker and would have used tools like an awl. A brown cotton work glove was found at the crime scene, very similar to the gloves that the petitioner used. Shortly before the murders, the petitioner took out $88,000 in life insurance policies on the victims. He had previously assaulted Jason with a gun and raped Judy during an altercation. He threatened to kill Judy on the phone while she was at work in front of her coworkers. He asked one of his coworkers to murder Judy in exchange for murdering the coworker's wife, and later offered another coworker $20,000 to murder the victims. Even completely excluding Sergeant Hunter's expert testimony about the fingerprint, there is no reasonable probability that the jury would have concluded that anyone other than the petitioner was guilty here. At trial, the petitioner raised an alibi defense. He argued that he was either at home or had driven to Kentucky. At the post-conviction hearing, he testified that he did not want to claim that the palm print was not his. Instead, he wanted to argue at trial that the palm print had been planted. Thus, there is no reasonable probability that had Ms. Bright Birnbaum's inconclusive report been available at the time of trial, that the jury would have not convicted him. And for the same reason, there's no probability that Ms. Bright Birnbaum's analysis would have led to a more favorable sentence. An inconclusive analysis just does not rise to the level of residual doubt in the face of numerous aggravating statutory circumstances that were raised by the state, and in the face of the state's circumstantial evidence here that I have listed in this case. Based on those determinations and these facts, the post-conviction court reasonably determined that the petitioner failed to establish his entitlement to fingerprint testing under Section 405. But even considering Ms. Bright Birnbaum's analysis, the petitioner also failed to establish his entitlement to a hearing under Section 412. The post-conviction court concluded that Ms. Bright Birnbaum's analysis did not exclude the petitioner as the source of the palm print or identify another person as the source of that palm print. And her testing results were at best inconclusive. And when we look at this court's precedent in cases where this court has interpreted the Fingerprint DNA Analysis Act, we see that such ambiguous, inconclusive results does not rise to the level of favorability. In Winston versus State, which this court decided in 2007, this court held that a mere lack of corroboration of the state's evidence fails to establish a petitioner's entitlement to a hearing. This court explicitly addressed the hearing provision of the Post-Conviction DNA Act and determined that lack of corroboration does not equal favorability. In Bondurant versus State, which this court decided in 2006, the petitioner had already obtained court-ordered DNA analysis. And that analysis found that there was no DNA on the item of evidence that had been tested. And the petitioner sought further testing to try and determine whether there was human DNA or animal DNA or just more intensive testing. And this court denied further testing because those inconclusive results of no DNA did not contradict the trial testimony of the state's expert and, quote, yielded no useful results at all. Similarly here, Ms. Bright Birnbaum's inconclusive and ambiguous analysis was not useful at all. It did not point to anyone else. She merely disagreed with the strength of Sergeant Hunter's conclusions about the print and that he had no doubt that the print matched the petitioner. Also in Waterford versus State, the evidence at issue was a knife, which did not have blood traces or the victim's DNA, but it did have 2 DNA profiles, but neither the victim nor the petitioner matched those 2 DNA profiles. So because the juror could have made multiple conclusions from this ambiguous evidence, these DNA results were not particularly favorable. And similarly here, based on Ms. Bright Birnbaum's ambiguous results, if her testimony had been presented at trial, the jury would have been left wondering, okay, well, where do we go from here? She disagreed with the strength. She didn't say conclusively, no, this is not the petitioner's, or yes, this matches someone else. Ambiguousness simply does not equate to favorability. And because Ms. Bright Birnbaum's analysis was not favorable, even taking her analysis, despite the fact that it was handpicked by the petitioner and did not comply with the clear framework of the Post-Conviction Fingerprint Analysis Act, the post-conviction court properly determined that the petitioner failed to establish his entitlement to a hearing, and thus the post-conviction court properly dismissed the petition. And unless this court has any further questions, the state respectfully requests that this court affirm the post-conviction court's decision. Thank you.
All right. Thank you, General Simpson. I don't see any questions from my colleagues. So, Ms. Harwell, you've got your full 5 minutes of rebuttal whenever you're ready.
Thank you, Your Honor. Unfortunately for the state, the standard as to whether we are entitled to testing or hearing is not the sufficiency of the evidence standard. It's not the way that the court looks at things on direct appeal or even on post-conviction. As I discussed briefly earlier, the standard is if you assume the results are favorable, would favorable evidence make a difference? That's the standard for testing. And then the standard for a hearing is our proof favorable? And the Attorney General just said that Ms. Bright Birnbaum's results are ambiguous. I submit they're far from ambiguous. Ms. Bright Birnbaum was very, very clear. Sergeant Hunter's identification of Mr. Smith is scientifically unsupported. It is unreliable junk science. That is not an ambiguous finding. That is very important, going to the heart both of the conviction here, but also the sentence. And that is to say, whether we're talking about testing or a hearing, under either the courts, this court's and the Supreme Court's case law says that the court has to consider all of the evidence. And the post-conviction court below, while reciting the same facts that the DA has now, the AG has now rattled off again in terms of sufficiency of the evidence, did not engage with any of our proof, did not engage with any of the proof that Ms. Bright Birnbaum put forward, that which is to say, any handprint evidence is by its very nature accidental. I don't know if any of your honors have had to be fingerprinted, but because I work for the federal government, I have had to be. And it requires a technician to laboriously roll each finger. When we touch surfaces and leave behind an accidental impression, we don't leave the complete print. This idea that you can just look at it and tell, well, if you could just look at it and tell, the state didn't need the imprimer of science in the form of Johnny Hunter as an expert to say it matched. It's because you can't look at it and tell that Sergeant Hunter's testimony was admissible in the first place. If the jury could have just looked at it and told, there would have been no need for an expert. And in fact, calling an expert would have been impermissible under the rules of evidence. It's because you cannot look at it and tell that Sergeant Hunter got to get on the stand and say, without a doubt, I got my man. And what we know from the exhibits we put before the post-conviction court that the post-conviction court refused to acknowledge, much less consider, is that the state itself considered the proof that it had before Sergeant Hunter made that identification to be a weak case. After the trial, after all of the proof was presented to the jury, then DA Blackburn, now Judge Blackburn in the criminal court of Davidson County, wrote a letter to the police chief. It's included in the record, where she said that the key thing, the most important evidence in this case, was Sergeant Hunter's identification. I think we have to take the state at its word. This print was what got our client convicted of this crime. Evidence that the science was junk science and unsupportable, that's not ambiguous. That is critical evidence that deserves a day in court, deserves a hearing at which we can ask the post-conviction court for a new trial under the Fingerprint Act. I thank you so much for the chance to argue for Mr. Smith.
All right. Thank you, Ms. Harwell. And both sides filed excellent briefs, and we'll take the matter under advisement, and we'll have the record provided to us also, and issue an opinion as soon as possible. All right. Mr. Hibner, anything else on the docket for us this morning?
No, Your Honor.
All right. If you'll just close court, then thank you.
This honorable court is now adjourned.